You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir. All right. Do you need a cause number?
Yeah, that'll be okay.
263-5194.
On 8/16/2026, officer was dispatched to 1415 Sunset Bay Circle residential area in Harris County, Texas, in reference to a suspicious vehicle that was parked outside of the residence. Upon arrival, officer made contact with the driver of the vehicle. The defendant, who was the sole occupant, defendant told the officer that he didn't live there, and that he was unsure why he was there. While speaking with the defendant, officer observed him to have red glossy eyes, slurred speech, unsteady balance, and there was a strong odor of alcohol emitting from his breath. Officer inventoried the car and discovered a case of Modelo, 3 missing, and a 1.75 liter bottle of Svedka, empty. SFSTs were attempted, HGN 6 out of 6, walk and turn refused, and 1 stand was refused. DIC was read and defendant consented to correct test, which came back 0.171 and 0.159.
What was the stop for?
He was asleep behind the wheel, in the car, and somebody called it in.
Was he in a moving lane of traffic?
Doesn't say, it's like, it wasn't a residential area in a cul-de-sac.
He was in a cul-de-sac
Yes,
on the street.
yes.
Okay. Mr. Arredondo, I'm going to find that there's probable cause to go forward with your case. Does he have a license to drive? And or does he have any prior DWIs?
There's no prior search and running license.
Hey, Craig, are you back on? Okay, we need to talk.
Yes, sir.
Yeah,
That's what
I guess just before you jet today, just
Yes.
let's talk.
I was gonna wait till after you finish your arraignment. That's
Okay.
what you're asking to.
She has a new arraignment? No? Or is it next week?
On Monday.
Monday,
but
okay.
I'm just gonna chat with you about it if I may, Judge.
Sure.
Driver's license is eligible.
All right, Mr. Arredondo, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, I will revoke your bond and put you in jail. Is it your statement that he had alcohol in the car while he's driving? You said there was a 12-pack,
There
3 are
was a
missing.
12-pack, and there was vodka also.
But did they
almost
have-
empty. It had a little bit at the bottom, but the bottle of vodka was in the car.
Were there any empty cans?
3 and, no, it says 3. No, it's,
Do you have a breath test? What is the test?
Yes, 0.175. 0.171 and 0.159.
Do you think we should put an interlock?
But I say yes, because it was the case Modelo, I was supposed to touch through the one you're saying.
Hold to the touch.
Yes.
I'm ordering you now not to drive any vehicle that's not equipped with an ignition interlock on it. I send notice to DPS in Austin so that every police officer in the state knows if you're pulled over and the car you're driving doesn't have an interlock, they're going to take you to jail and you're in violation of these bond conditions and I will revoke your bond. There will be no more PR bonds for you. This is not a revolving door. Do you understand me? Yes or no?
Yes, sir.
How old are you, Mr. Arredondo?
22 years old.
What do you do for a living?
I am a bull rigger currently in the government industries of verified.
So you have a full-time job? And what kind of money do you make a month?
36.
Got it. We're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign a reset. We'll have you get with Veronica for your bond conditions. And after that, you'll be free to go, sir. Please.
All right, top of three, Logan.
Hey, take a look at what I'm printing. All right. Good morning, Mr. Bolden. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On 8/14/2026, officer was dispatched to 5727 Peacock Street in Harris County, Texas, in reference to an assault. Upon arrival, a child flagged officer down and stated her mother and father were fighting and that there was blood in the living room. Officer entered the residence and observed defendant close the bathroom door. Officer asked if anyone needed assistance and defendant partially opened the door and said, "Hold on." While the door was open, officer observed the complainant to be holding a towel up to her face. Officer told defendant to exit the bathroom and he was detained without incident. Officer then spoke to complainant who stated her and defendant had been in a verbal argument. Complainant stated defendant then threw an iPhone directly at her face, causing her nose to bleed profusely. Defendant then admitted to throwing the phone at CW's face. Also observed blood in the living room, bathroom, and all over the complainant's body. They have been in a dating relationship for 6 years.
Mr. Bolden, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol. I'm ordering you not to have any contact with the complaining witness in this case and not to be in possession of any weapons. Do you mind filing a new protective order, please? Because one that the magistrate filed marked out the no contact, and I don't think that he should have contact with her at all.
Yes,
Please, because I don't want it to look even more messy than it would be. I'm entering now what's called a magistrate order for emergency protection, which identifies Ms. Edwards as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Peacock Street house in Houston, Texas. If you violate this, they can file additional cases against you, and a violation of a protective order is one of the worst cases you can pick up. Do you understand? Mr. Bolden, I'm going to protect everybody in my city at all costs. And if I have to throw you in jail at a $5 million bond, I mean, really, there are no mistakes. There are choices in this life. You either make a good choice or you make a bad choice. Do you understand? You have the ability to hire a lawyer. Do you have the ability to hire a lawyer?
Yes, sir.
Okay, we will give you time. Have you sign a reset. I'm going to have you take a seat in the jury box so we get your bond conditions. And then after that, we'll let you go. Come on. State's conditions. Yeah. Do you also mind? No contact, no weapons, please.
All right, page 5, F. X.
I believe this is one outside of public attorney.
Oh, okay, Fraser. Oh.
I mean, barely over a month, man. Don't say anything. I'm just barely over a month. And now you're charged with resisting arrest. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On 8/14/2026, officer was dispatched to the 307 block of El Dorado Boulevard in reference to an indecent exposure call. The recording party stated an older white male was exposing his genitals to the customers in the patio area. Provided descriptions, 60s, blue shirt, black pants, walking a dog. Upon arrival, officer made contact with a witness who pointed out where the defendant was. Officer then made contact with the defendant and he appeared to be intoxicated. Officer told defendant to release his dog, but defendant refused to comply. Officer then attempted to detain the defendant, but he began pushing, pulling his arm away and physically struggling with officer. Another officer arrived on the scene and they were eventually able to detain him after a struggle.
Tell me about the indecent exposure allegation. Do we know whether it's going to come down? No? Is there?
A new charge.
Yeah, I mean, you're saying he was,
No.
Mr. Fleischer, I'm going to find that there's probable cause to go forward with your case. Don't.
50-minute ride and speak almost behind.
It's really just not a good idea. I'll get you a lawyer today. Tell your side to the lawyer. Okay. As a condition of your bond, I'm ordering you not to consume alcohol and I'm going to give you a device to make sure that you're not using it. Go on your ankle. It's going to detect alcohol 24 hours a day, 7 days a week. Do not use. Otherwise, I will put you in jail and I'm not going to play this game again. You're also not allowed to go back to this. What was it a bar or what was it? You're not to go back to the location of where these alleged occurrence occurred, and you're not to have any contact with any of the complaining witnesses. Victoria, do you mind appointing him a lawyer?
Yes, Judge.
I'm going to have you sign a reset. You'll get with Veronica for your bond conditions, then we'll have you take a signature box.
Right this way.
Judge, I had to reach out to the attorney charges because intentionally I'm not seeing anything about sexual gratification.
Okay,
It's just exposure.
got it.
Judge page 6 and 7, Hawkins.
Good morning, Mr. Hawkins. Sir, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. Actually, you're charged with 2 counts of theft. We're going to do probable cause on both of those. Excuse me, you have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Was it Hawkins?
Hawkins, yeah. 2 thefts.
On 8/14/2026, officer was dispatched to 9915 FM 1960 Road, apartment complex in Harrison, Texas, in reference to a theft. Upon arrival, officer made contact with the CW who stated he exited his apartment and observed his white Ford Super Duty pickup truck to be missing. It's tailgate. CW then began searching Facebook Marketplace for another tailgate when he came across his. And was able to identify it by the silver decal and reflective tape he had put on it. CW then called 911 and set up a meeting with the seller. The defendant, once CW took possession of the tailgate, deputies moved in and were able to detain co-defendant after he ran approximately 50 to 60 feet. Officers were then able to detain defendant and CW pointed him out. The man who ran the Facebook page, who was waiting in the car, was a co-defendant and verified through photos on the account.
How do we know? So do we have 2 tailgates or 1 tailgate?
One. There's one and there's defendant and co-defendant
Well, he's charged with two. Is it a duplicate?
He knows better.
Judge, the co-defendant is the one who made the hand-to-hand transaction, whereas the defendant is the one who runs the Facebook page where it's listed.
Okay, so how do you charge him with theft? Just because he had possession of allegedly stolen
I guess
merchandise?
they're assuming since he was the one who posted it, that he was the one who took possession of the tailgate.
Right, so, and there's a charge for exactly for that. But, you know, if you can show me that he went in the middle of the night and you have him on video, or you have some kind of cooperating witness who can put him at taking the tailgate in the middle of the night, that's one thing. But just having possession of stolen property, Karina, what do you think? Hawkins, and there's two counts, but only one tailgate unless there's something else. If you can put him at the scene where the property was taken,
Yeah, maybe so, I just double.
That's what I was calling. Oh, so it's a duplicate. Yeah, the other one is a duplicate finally.
it's a duplicate, okay, got it.
Thank you.
So Judge, on the actual event summary, I'm not seeing how they ID that's the person that stole it. So this charge was unlawfully or appropriate or by applying otherwise exercising control over the property. That's how it's charged. So it's not charged as like you have to steal it, it's just acquiring, or having control or exercising control over the property and the information. So you know that they.
How do you show that he knew it was stolen?
Let me pull up the actual statute, how it's charged, Judge.
It's a specific intent crime. So you would have to at least show that he knew it was owned by a Martinez.
Yes, Madam. Judge was too sure. Good, as well as the information that we have right now, which is in summary, he knew was not his property. When he got control of the other portions in regards to whether or not he lawfully obtained the property. I would have to look at that information a little more, just like we do already have the office report. To be able to answer that question, how did.
You want to take maybe 20 minutes, 15 minutes? Okay, take a seat for me in the jury box, please. We'll come back. Eric, you ready? Is Villanueva here? Villanueva, coming up.
Page 17.
Did you see speak English?
Yes.
So we've had this case open for 2024, he has two different bond violations. Failed to obtain an interlock,
Those are from 2020.
and then 20 skips. Yeah. Mr. Villanueva, as a condition of your bond, I'm on one ankle going to put a GPS monitor so I know where you are at all times. On your other ankle, you will get a scram ankle monitor so I know that you're not consuming alcohol. If you violate any of these conditions, your bond is at 2503. It should be, my bonds are usually typically way higher on a third non-appearance or a third bond violation. Do you understand? You take off, you violate any of these conditions, I'm going to go bananas on your bond. As it stands now, we set cases for trial at 180 days. To give you a little perspective, your case is 892 days old. You get one setting, 30 days. At that time, you must be back here and decide whether you want to accept this plea bargain agreement, or I'm going to set your case for trial and there will be no more. Do you understand? No more plea bargain agreements. This is the plea bargain deadline that you have. I'll sign your motion to sub, gives you 30 days, and then just come back and let us know. If you don't mind, please put an offer on the case. And I'm assuming that he doesn't have a license, please. Because we did a no driving affidavit before.
Yeah, that license is not valid.
Sorry,
It's had a license before, but it's not valid.
Yeah. You signed an affidavit promising us you're not going to drive. I don't care what the heck you have to do in this life. You drive. Again, I can hold you in contempt and slap you with 180 days every time you drive. Do you understand? Do not drive. Okay, great. We'll see you in 30 days.
Thanks.
Mr. Thering,
Your Honor.
what's up, bud?
How you doing?
Happy Friday, man.
I have Ms. Epps on your
Okay.
docket.
Ms. Epps, coming up, man.
All right.
Yes, I signed it. I signed it, but it didn't let me stop.
What's that?
Good news, Judge. 15 kids gone.
Wow.
Didn't want to reveal the.
Federal case or what? Yeah.
No,
I-
it was supposed to be federal. It's up in Waller County. I've been working that thing for about 9 months. And we just got the knowledge.
That's a-
It's not signed yet.
It's a doozy. Good morning, Ms. Epps. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can be used against you.
Yes, sir. On August 16, 2026, an officer was dispatched to 8541 State Highway 298, which is a public roadway in Harris County, Texas, in reference to a crash. Upon arrival, the officer observed a black Kia crash in the crash cushion on the side of the highway, appearing to be totaled. The officer then made contact with the defendant, who was standing next to the vehicle. The defendant admitted to driving the vehicle and said she crashed because she jerked the wheel. While speaking with the defendant, the officer observed her to have glossy eyes, slurred speech, unsteady balance, and there was a strong odor of alcohol emanating from her breath. Field sobriety tests were then conducted with 4 out of 6 clues on the HPN, 8 out of 8 clues on the walk and turn, and 4 out of 4 clues on the one-legged stand. The IC was read, but the defendant refused to consent to blood tests, and then a blood warrant is then signed and executed.
Okay, does she have any prior DWIs and does she have a
She has
license?
no criminal history.
Okay, license? Epps. Ms. Epps, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, your bond can be revoked and you can go into custody. You understand? You are not allowed to drive unless you have a valid Texas driver license and a liability insurance. You must also maintain insurance because, great. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Thering and he'll tell you if and when you have to come back to court. Just don't use and all will be fine. All right. Okay. We'll have you sign your conditions and after that you're free to go. Always a pleasure.
I didn't sign for your research. All right, Judge, next is page 12, Pineda. Go ahead and see the ones up on you. I shall. Let's see, you gave me.
Good morning, sir.
No.
You do speak English.
Yeah, I do.
Okay. Mr. Pineda, you're charged with driving while intoxicated, second offense. That is also elevated to a class A misdemeanors. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir. Good morning.
On August 15, 2026, an officer was conducting routine traffic patrol in Harris County, Texas. When they observed a GMC Sierra making unsafe lane changes, the car was abruptly changing lanes with no turn signals. A traffic stop was conducted and the officer made contact with the driver, the defendant. While speaking with the defendant, the officer observed him to have bloodshot eyes, slurred speech, and there was a strong odor of alcohol emitting from his breath. Field sobriety tests were then conducted with 6 out of 6 clues on the HGN, 4 out of 8 on the walk and turn, and 3 out of 4 on the one-legged stand. The GIC was read and the defendant consented to breath test with the result being a .161 and a .165. The officer also located a beer can in the vehicle during the inventory search.
I would venture guess that it's damn elementary that you're not to have alcohol in the car while you're driving, and it's a mandatory, almost nearly a week in jail if it's proven at trial. I'm going to find that there's probable cause to go forward with your case, Mr. Pineda. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. Because this is a second offense, I'm now ordering you not to drive any vehicle that's not equipped with an ignition interlock on it. Does he have an interlock? I'm serious, does he have a license? Pineda.
He does have a license on.
It's valid though, with
Yes.
DPS? Okay.
His driver's license shows eligible, but expired in 2013.
Is what?
Is eligible, but it expired in 2013, so he's eligible to obtain a driver's license, but it hasn't been
But
expired.
he does not have a license.
So he does not have a valid.
He may have a physical license, yes, but it expired, so it's not a valid license.
As far as I can tell, 'cause I looked at it, but I haven't win it, and it's.
I understand that.
It's not expired on the face of it, so I didn't know it's expired. If it is expired, it's not on.
Are you sure? She's looking at she has access to the DPS system. I don't know if you want to go look now to see, because if he doesn't have a valid license, I'm going to order him not to drive.
They can double check the license number, but from what I have here in our system with his name and his date of birth, it's showing expired since 2013.
Okay, so let's do this. Why don't we have you sign a reset? We'll have you sign your conditions now. I'm going to have you take a seat and you guys hash it out and then just let me know if it's expired or not.
Yes, sir.
If it's expired, he will get a portable device that he's going to take everywhere he goes, and he'll have to sign a non-driving affidavit until it's remedied. Let me get this ready.
Just discuss it with-
Yeah, and then just let me know. And then also, counsel, have you filed an attorney of record?
Yeah, I followed it.
It's indeed, okay, great. All right, thanks.
Right this way. All right, Judge, top of 15, Taylor, counsel on this side.
I'm gonna do have that just.
House October 23.
What was your last name? Taylor. All right, Mr. Taylor, you were also charged with driving while intoxicated, a second offense. You were facing up to a year in jail and or a $4,000 fine. This case is from 2023. Mr. Taylor, probable cause has already been found in your case. Your case is 1,322 days old. We set cases for trial at 180 days. You're going to get a 30-day reset. When you come back, you must either accept a plea bargain agreement or I will set your case for trial. You will be required to go hire a lawyer. You don't qualify for a court-appointed lawyer. Because of how old this case is, I'm going to put a GPS monitor on your ankle. We want to know where you are at all times. Also, because it's a second offense, and because of this, I'm now also placing an additional restriction where you will get a scram on your ankle so I know that you're not consuming alcohol. You are not allowed to drive any vehicle that's not equipped with an ignition interlock. And from what I can tell, you do not have a valid Texas driver license, so you were also ordered not to drive. You understand? The worst possible thing you can do in this life is if you take off again, it's not going to go well between us. You understand me? All right, I'm going to have you come swear to us that you're not going to drive. I'm going to have you sign a reset. You'll get with Ron for your bond conditions, then we'll see you in 30 days.
All right, Judge, next is 18 William, come on up. Judge, 30 days gate change.
Yeah, and then the next setting is clear trial too.
Yes, sir.
What is your last name? Williams.
Mr. Taylor.
Ms. Williams, you were charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On August 15th, 2026, an officer was dispatched at 4010 East Freeway, which is a public roadway in Harris County, Texas, in reference to a minor accident. While en route, the officer was informed that the defendant had left the scene in a Nissan Maxima and the license plate was provided. The officer located the defendant's vehicle and conducted a traffic stop. The defendant stated the complaining witness hit her vehicle coming out of the Buc-ee's parking lot and he wanted to exchange information. The defendant showed the officer a video of her saying, "He won't give me his information." The officer then observed the complaining witness roll his window down and say, "I'll give my information when the police come." The defendant also stated she tried calling the police non-emergency line, but the officer observed it to be for the Houston Police Department, not Baytown. The defendant was then unable to provide proof of financial responsibility. Another officer contacted the complaining witness, and he said the defendant hit him while exiting Buc-ee's. The complaining witness
So
said,
this is a second person?
this is the other person involved in the accident.
Okay.
The complaining witness stated the defendant hit him while he was exiting Buc-ee's, and then he said the defendant then got out of her vehicle and began blaming him for the accident while recording. The officers observed security footage from Buc-ee's that supported the complaining witness's story.
All right, Ms. Williams, I'm going to find that there's probable cause to go forward with your case. Does she have a license to drive?
This is Williams.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance in your name, it is a condition that you don't drive. If you do, I can revoke your bond and put you in jail and give you a high bond. Do you understand? Do you mind filing those conditions, please, guys? On Ms. Williams, no driving without a valid license and insurance, please.
She has an eligible license, Judge.
Okay. How old are you, ma'am?
Thank you.
How do you support yourself?
I just got it out.
Doing what?
Inventory.
Is that it? What is that? What kind of money, do you have the ability to hire a lawyer? Can you afford a lawyer? How much money are you making a month, ma'am?
I just started 2 days ago.
Can you give her an application, please? I'm going to give you an application for an appointed lawyer. I need to know everything about you and then we'll see whether you qualify. Okay. Do not leave until you sign our bond conditions, Ms. Williams.
States bond condition?
Yes, states.
I'm gonna sign for your-
Hi, are you ready?
Yes, ma'am.
Coming up.
It's on your trial docket, but it's off docket.
Sure, of course.
I have a case number.
Bear with me. Is this on next Tuesday?
Yes.
Okay, what's your cause number?
360-2033. John Azar.
Okay,
Well, this one, Your Honor, the state had offered if you pay $200 within 30 days, the case will be dismissed. That's an offer. Problem is, I can't get a hold of my client. It's only done at 25 days. And I think I'm calling them because we're set for trial. I have to prepare for trial. I can't prepare for trial.
so let's do this. Pick a day next week.
Okay.
Let's set up for bond forfeiture and reach out to him however you can and say, look, The judge has put this case on the docket. If you fail to appear, your bond will be revoked and we'll go from there. But I mean,
That's right, his phone number, the registered number,
it is what it is. If they don't want to be found,
Okay.
so
Thank you.
for sure. Thanks. Ready?
More judge.
Hi, good morning.
Here on Dotson case, Lorenzo
Page
Dotson,
4.
on a trespass case.
Okay, Dotson, come up. Is Chumbly?
That person didn't check in, Judge.
Okay, 2501, if this is a no-show. All right, sir, you are charged with criminal trespass. You're facing up to 6 months in jail and or $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On August 2026, an officer was dispatched at 4702 Scott Street, which is an Exxon gas station in Harris County, Texas, in reference to a suspicious person. The call note stated 3 individuals were playing dice on the property. Upon arrival, the officer observed 3 individuals playing dice, one of them being the defendant. Once they saw officers, the men dispersed and the defendant went inside a vehicle. The officer made contact with the defendant and asked him to step out of the vehicle, and he was detained. The officer then spoke to the complaining witness, who's the employee of the gas station, who stated he asked the men to leave earlier that day, but they refused. The complaining witness stated he has had issues with these 3 men doing the same activity on the property over the last few months.
Got it. Mr. Dotson, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to go back to this location. Do you understand? If you do, I will revoke your bond and put you in jail. There will be no more PR bonds. Do you understand, sir? Do you mind reaching out to the store owner and let them know the conditions that we place? So in the event that he goes back, they'll let us know and then we can take the appropriate action. Because if he doesn't know, he's, okay. So because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with counsel. We will have bond conditions created for you to sign. Do not leave until you sign them. Do you understand? Okay, we'll have you sign a receipt and then you're good to go.
Good,
Thank you. Have you filed an attorney of record?
I
yet?
just
now? Okay, wonderful.
Sign.
Thanks. Hi.
Hi.
Sure. I guess so.
All right, go ahead and have a seat in the jury. box.
Yeah, just don't go back. But I guess if you,
That's it.
ready? Come on up. Hi. Good morning. This is from the other day.
Yes, sir.
Okay, have you been able to speak with him or her? I don't know.
She's across the hall and more dates a little bit.
What's the last name?
Hernandez.
Hernandez. Oh, that's right. Do you mind bringing her out? Let me go. I'm gonna go. Give me 2 seconds.
Mr. Golden?
Okay. No, I don't, you need to translate it.
No.
Okay.
But I mean,
I guess it's taking a while. Any luck?
Yes, I just wanted to let you know, driver license.
Good. Okay. All right. So we'll do the guard interlock then. Okay. Thanks. Appreciate it.
Anyway, how you doing, Judge?
Good. It's Friday. I'm so ready to wake up late tomorrow.
I,
So
oh, you
ready.
know what? Yeah. I was about to say the same thing. I'm an online racing team waiting for a 24-hour race tomorrow. So I think I
A
said,
24-hour race?
there's endurance racing, so we swap drivers every couple of hours maybe.
Whoa.
But they're from.
What do you race?
Oh, we're racing 9/11.
Ah, I'm so jealous. Here I am in my jalopy. Oh, good time. Good morning, Mr. Hernandez. I wanted to bring you out because it's only fair that you get to listen what's going on because it's your case regardless. You're charged with violation of a protective order or a bond condition. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, man. Okay.
On August 2026, the deputy responded to a residence in Harris County, Texas, in reference to a family disturbance. Upon arrival, the note stated the defendant, his girlfriend, accused him of infidelity during an argument and slapped him on the left side of his face with an open palm. The complaining witness reported no pain, he had no visible injuries, and he did not wish to pursue assault charges. The deputy then contacted the defendant. She denied slapping the complaining witness, claiming the altercation was only verbal. The officer then ran her information through NCIC, TCIC, and discovered that she had an active temporary protective order valid through August 2026.
When did this occur?
This occurred on August Judge.
Okay, so about 3 weeks, give or take. Where's the temporary protect? Is that at the 280th? Do you know? Let's see if I can find
I
the
believe
two.
it should be out of the Court 2, Judge.
No. Oh. Court 2.
For the assaulted family member about Andrew. It was filed in April 2026.
Council for reset.
I don't understand.
Which one was Hernandez, Judge?
Yeah.
So she had, the social member that was pled back in 2026 when we wanted therapy, reduced it from the previous conviction to just a regular.
Okay, so it's out of the 183rd.
Yes, Judge.
Okay, because I was looking at the Court 2 stuff and it was,
We did have a prior also from court too, so that's probably what he was thinking about.
Yeah.
That one, I guess,
are
was-
all of them the same complaining witness?
Yes, Judge. And we attempted to contact him up in once again.
Got it. Okay. Floor is yours. Do you have any argument?
We waived bail until today's setting because I figured that we'd be able to, one, dispose of the matter, and two, I didn't think that you were likely to let her out considering the history. Yeah, it's already been about roughly 2 weeks since I received the case. My client's been not able to make bond, has been since dropped from college, so it's set back a semester. Her child is with the complainant right now, and she's just sitting otherwise waiting for.
Is it their child?
Yes,
Their child.
yes.
Yeah, okay.
And so I'm asking for at the very least a rejection, best PR, because she'll just be sitting here while we wait for discovery to be committed.
So my concern is that she has 3 assaults, all against the same person, all recently disposed within the last 4. Yeah, I mean,
In custody, I've advised my client as to what your concerns would be, so whatever the conditions you feel are appropriate, that's.
I just don't think a bond reduction is appropriate, ma'am. There are no non-financial conditions that I think that we can put in place that will ensure the, community safety. You're now on a 4th within the last couple months. I want you to hear me, and I want you to hear me loud and clear, Mr. Hernandez. The Texas Constitution does not allow me, but in extremely limited circumstances, to have a hearing to hold someone at no bond. You're now in that situation. If you attempt any contact, if you attempt anything with the complaining witness in this case, I can have a hearing to hold you at zero bond. Do you understand? I don't know if you're going to bond out now, but if you do, you will get a GPS monitor prior to your release. You're not to go within 1,000 feet of where he lives or where he works. Do you understand? What's your position on the bond reduction?
We're opposed, I mean, yeah, the history, recentness of the last incident, she's not even still like, the fact that he has to give their freedom more to go back and make contact with him, which she's not supposed.
If some time passes and she isn't able to, I'll consider a reduction. At the time now, due to the recency of all these cases, I have just really grave concerns. But given some time, if she's still unable, come back and then we can talk and then
Regarding what sometime means.
I don't know.
Roger. Thank you, Judge.
Yeah, for sure. Okay. All right. Good luck, man.
Thank you, Judge.
Wait, we need her to sign. Counsel, you ready? Bless you. Bless you. Hi. good morning. Jail or bond? Okay. Oh, she has a BVR.
Yes.
Okay. Is she here?
Yes.
Ms. Gardner, come up. Is this a first or second violation, Veronica, on Gardner?
Whenever you're ready.
I'm now going to place an ankle monitor on you that will be on you 24/7 to ensure that you're not consuming anything. After this, I really have nothing left at my disposal other than putting you in jail. Do you understand? No means no. I don't give a rat's behind what is what. How old is this? Let's see. Okay, you will also be tested within 50 days of the time that we put bond conditions on you. If you test positive for anything illegal, it may not go well for you. Do you understand? Okay, I'm going to amend the bond condition, put a scram on her today. We'll go from there.
Thank you. Oh, shoot, yes. Thank you. Yes.
Johnson?
No talking in the box. Hey.
All right, go ahead and start.
May I approach your honor?
Yes.
You done?
Hi.
I have, August, there, Abraham, he was just sent to go and do a test.
Okay.
I just want to let you know, I'm here. Because you're ready.
Oh, great. Okay. Thank you for coming.
No problem, I'm
So
Shiva.
the BVR is. Okay, great. It's a second BVR.
Well, the first one, your honor, was, about showing whether or not he was.
I understand. Okay. I got it. You're good.
Okay,
All right. But I mean, I want to see what,
absolutely.
let's see what the test comes back and then
Yes,
we'll.
yes.
Yeah, okay.
Yes. They want to be saying.
Oh, okay, already, thank you. Judge, we have one late arraignment,
Okay.
top of 16, Thompson. Come on up.
Up here, ma'am. All right, Ms. Thompson, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
On August 14, 2026, an officer was dispatched to 291 IH 45 freeway, which is a Hobby Lobby in Harris County, Texas, in reference to a female patron concealing items in her purse. The officer arrived at the location and waited outside in order to give the defendant an opportunity to pay for the items. Though the defendant passed all points of sale without making any attempt to render payment for the items, and she was stopped by the officer and the complaining witness, who is a loss prevention employee. The defendant was taken back to the loss prevention office and the items were recovered from her purse. This was mostly jewelry. The total value of the merchandise was $148.80.
All right, Ms. Thompson, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you're ordered not to go to any Hobby Lobby whatsoever for any reason. If you do this or you pick up a new case, it's very possible that your bond gets revoked and you will go into custody. Do you understand? Do you have the ability to hire a lawyer, ma'am? Are you working at this time? Okay. If you want to apply for a court-appointed lawyer, I need you to fill out an application. I need to know everything about you. I need to know how much money you have coming in. Cars, stocks, bonds, mutual funds, IRAs, whether you're married, another household person that's bringing in income as well. You understand? Okay. Deputy Williams, do you mind giving an application, please? Thanks. Where we'll have bond conditions created for you to sign. Do not leave until you sign the bond conditions. Okay? All right. Please. Can you ask them to file no Hobby Lobby?
Judge, bottom of 8, top of 9, KC is the last name of the initial KC. Come on up.
Yes.
Morning, Judge.
Rahan, what's up, bud?
Can't complain, Judge. Can't complain. Judge, we have Mr. Casey. He's in the gallery.
Do you mind bringing him up? Do you speak English?
Oh, yes, sir.
Okay.
Same transaction, Judge.
Okay.
Um,
Good morning, Mr. Casey. Sir, you're charged with a game room violation operating one without a permit and failing to post a sign as well. On both of those, you are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Okay.
On August 10, 2026, officers arrived at 6916 Ashcroft Drive, which is the Dollar Lucky in Harris County, Texas, in order to conduct a convenience store inspection. During the inspection, the officers discovered there were 10 amusement redemption machines in the store, with 5 of them lacking current City of Houston and State of Texas tax stamps. Given that there were now 10 machines, this turned into a game room investigation. The officers contacted the owner of the store, the defendant, and he agreed to meet with them on August 13, 2026, in regards to his violations, given that he now had more than 5 machines. During the meeting, the officers advised him of his violations: 1, carrying or operating without a permit, and 2, failure to comply with signage requirements. If you have more than 5 machines, you must pay the required fees and acquire a permit, and you must have a sign that says this is a game room outside the area, and the defendant had neither of these.
Okay,
Here's the thing, so 5 of them were working and they were with permits, right? And then there's 5 in the back room, right? That were not permitted on the basis, right? So it's a convenience store, right? It is a convenience store.
are you telling me 5 of them were inoperable? Is that what you're saying?
Now, that's where I'm going with this, but what I read in the PC was that one of the machines in the back, right, was working, right? That was open. I mean, if I read it correctly, one of the 5 that was in the back was working. They're like, okay, well, that's, that's what they're doing. They're grouping it.
What does the statute say? Does it have to be all operational?
See, the way they're saying is like 10. All right, that's it. We're good, right? Oh, more than 5, we're good. We're good.
But what does the statute
That's
say?
okay. We have to go back and look at it.
Are you familiar?
So Governor,
No. Second one.
They're saying one of
Because Rahan is saying that some are inoperable. I have to imagine that the statute contemplates people being actively able to gamble.
Well, Judge.
I don't know.
It shows 4 of them were on and operating, only one of them was not.
But he's saying you have to have more than 5 to be able to
That's what they're.
offend the statute, so to
the
speak.
officers are saying 9 were operating.
That's what they're saying, correct? It's, it should be.
But I mean, I can't take it at face value,
For sure.
right?
Yeah.
So if you bring me evidence to the contrary, I'm happy to rehear PC at any time.
Yeah, we can double check that just to make sure that the only case, I never had to see what number.
Rahan, I'm going to find it for now. I'm not putting any conditions on him. Just stay out of trouble. Don't pick up any new cases. You got a great lawyer, listen to him. If you find something to the contrary, bring it, show her so she can see it, and then we can have another hearing. I'm happy to do it.
Well, 5 of them did have permits and 5 of them were in the back, and that's the issue that we're gonna face. What's one of those?
So 5 had active permits?
Absolutely, in the front, 5 of them did, and then there's 5 in the back room. That's the contention in terms of.
Bring proof.
I'll look at it, Judge.
Because I mean, if that's the case, then he doesn't have 10. He's got 5.
Correct. That's why I'll double check it out. I'll read it again, Judge, just to make sure everybody can see.
Yeah, just, they're great. Yeah, okay. So I'm going to have you sign a reset and then we'll just let you go and then just stay in contact. Okay? Okay, thanks. No conditions. No, no. Thanks, Rahan. Good to see you, man.
Good to see you. Sign in just a moment. Judge, we have another arraignment.
Okay.
Bottom of 3, Shumley.
Oh, this, we already did the co-defendant on this one. Yeah.
Yes, sir.
All right, go ahead and sign.
All right. Good morning, Mr. Chumley. You're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do, well, I have already done probable cause on your co-defendant and found that there's enough probable cause to go forward. As a condition of your bond, I'm ordering you not to go back to this Exxon gas station whatsoever for any reason. You will be signing bond conditions promising us that you will not go. If you violate this, your bond can be revoked and you can be facing more time in custody. Do you understand? I can revoke it, put you in there, no more PR bonds for you. Let's look at Mr. Chumley. We are going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria Center reset. I will have you take a seat in the jury box. Once you sign the conditions, at that point, you'll be out of here. When you come back, please have a lawyer. Well, so can you file no going back?
All right, go ahead. All right, go ahead and have a seat in the jury box. Judge, did you want to revisit bottom of six, top of seven?
I don't know if she's ready.
Oh,
I didn't
I
ask.
didn't hear why, I just.
She was gonna look something up.
Yeah, I'm looking up Judge in regards to.
Take your time. There's no rush.
Yeah, no rush.
Don't,
I thought
there's no
we-
rush,
Yeah.
really. You only have 30 minutes because we're in. Hey, we need to get a commitment to see if dude's coming today for those 3 cases. If not, then we need to reappoint someone else. Don't you think?
For the future case.
Yeah. I mean, if he's been enrolled 3 times and we don't know if he's coming today, then he needs another lawyer. He cannot get just bumped, and then we don't even know if he's coming here today. I mean, I guess if you want to reach out to Ms. Parker, see what she says.
Okay.
But I don't want to get to noon, he's still not here, and then we got to real.
Yes, Judge, I'm gonna email her right here.
Alonji, make sure she doesn't leave until she signs bond's conditions.
Okay.
Okay.
Judge, I have an answer.
Two.
So even though, intent can be inferred, there, when the officers are mark to the location to try to retrieve the stolen for harassed complainant. The complainant found that inside the garage that belonged and was connected to the defendant, there were multiple other bumpers, which also were not. So I've looked at the info in regards to that, and it says that it's handling for, when there is other evidence to support that maybe not just one, but when you have multiple stolen properties that you knew that should have been made sure that all the property was stolen. If it was just one, I would say no, there's no evidence that it was properly.
There are multiple bumpers in there. Did they confiscate them? Do you know?
Yes. We did a search warrant to search the garage.
What was his last name again? Hawkins, come up. So there's two copies. There's a duplicate. Which one do you want to get rid of?
It's because, there's multiple,
Oh, so it's not duplicate
there's
then.
gonna be two complainants that we got the information.
You can ask.
It's not. I think it's a duplicate because
Yeah, it's the both the same complainant.
it's both same complainant, same day. Maybe it's an oversight or some, they put a different, should have, but
So I'll,
I don't know if you want to indict it or what, but pick which one you want to go on.
yes, Judge, I was checking to see if there's any conditions on any of that. And I'll probably be fixing the newer one, 979, keep the lower cause number. I think just get filed.
You want to keep the lower one?
Yes, Judge.
Then, so 979.
Yes, I'll just 971.
Got, oh, wait, you'll
Oh, wait,
dismiss.
sorry,
983, okay. Mr. Hawkins, you're charged with theft. I'm going to find that there's probable cause, bless you, probable cause to go forward with your case as a condition of your bond. I'm ordering you not to have any contact with the complaining witness, co-defendant, and not to use Facebook Marketplace anymore. If you do, I can revoke your bond, put you in jail. This is not a revolving door. You will not get PR bond after PR bond. Do you understand, sir?
Judge, today's bond conditions or?
No using Facebook Marketplace, no contact with complaining witness or co-defendant. How old are you, Mr. Hawkins? What do you do for a living?
Get into the children, right now, the last
And what kind of money do you make a month?
estimated maybe around $25 to $60.
Judge, still just like to add like any of those online selling like off the auction, things like that as well, not just Facebook.
Yeah, I think this is probably a good idea. Okay. Did you want to apply for a court-appointed lawyer? Do you mind giving an application? Well, I'm going to give you an application, Mr. Hawkins. I don't know who you have in this life, but I'm warning you now that I'm going to protect my community at all costs. I have no qualms. I'm not going to lose sleep over throwing your butt in jail at $100,000, $200,000, $500,000 bond. I'm going to protect my community at all costs, every single person. You understand? Okay, we'll have you sign a reset. I'm going to have you take a seat in the jury box, fill it out, and then we'll take a look to see whether you qualify. And then, ready? Hey. So this is a very, very preliminary investigation. I'm going to tell you now that with the new cases that she has, I'm not going to make any decisions until she's here because I want to see her. Okay, what you got?
I'm just here to kind of talk to you about it and kind of try to figure out, hopefully, what I think she needs, Ms. Stefanski, to be quite frank, is I think she needs, the help and support to get out of this rut of addiction.
You mean hopes and prayers, you mean?
I think like so report and, whatever tools that we have, and we can figure out to try to get her.
Yeah,
Assistance, and I'm amenable to, doing that or putting her under a rehab or whatever it is that, we need to do, I guess. I don't want to see her back just as much as you.
Sure, I understand, but I guess we would have to do another TRAS. I mean, that's the only way. So let's wait for her to get here. It's Monday, and then we'll go from there. But all she did was pick up another inhalant case, right? It's not DWI, or is it? It's a DWI inhalant? Okay.
And so I've already spoken.
And she's on probation for DWI too, right? Yeah, right. Okay.
She's on probation right now. And, I think I've spoken to her. I've already started on narcotics and honest classes and started with therapy, but I know she needs a lot more help than I can show you her friend,
Yeah.
But I'm just trying to get her started on something on day one, just so until we can figure out, what that more intensive treatment looks like. And so I know that.
I think that we did IOP, didn't we?
Yes, Ron.
We did already. Did we do Safe P SATF? Which one did we do?
She did some inpatient treatment already, yes, she did, where she was locked in and she was.
Was this one where you guys put her in one of your own choosing, or was it one that
I
we
think
did?
we agreed to, Your Honor, is kind of what we do, and so, with the court or with the state, she's been through the safety program. And so I don't know. I'm looking for more.
She hasn't been to Safe P. She's been to your rehab facility.
No, she did a government. She did one where she was locked in. I think it was called.
Can I get a spinner cost?
Sure.
I mean, really, but it's neither here nor there. There's no
Right,
there's no need for you to do extra work because there's nothing that we're gonna do anyways today. Let's let's get her here Monday and we'll talk and then we'll go from there. Yeah. I'm with you too, as far as I don't want to keep doing the same thing over and over in hopes that it sticks when we've already know that it's, I don't know. I'm going to have to reach out to the director of CDC, the Community Supervision Department, to see what other option we have other than Safe P, whether it's DDRP or I don't know. So.
Yeah, that's why I was kind of asking you that question this morning about, what is sober court like? What does that entail? What kind of monitoring is there? What kind of treatment options do they have?
I don't even know.
What tools do we have, right?
Yeah.
I did put out a handbook. It goes over the details of the program and the guidelines and conditions and yours to be a substitute.
I'm amenable to put her in sober court if you and the judge. but
I don't know. We may be beyond that at this point.
So I just worry about.
We did inpatient treatment last time. She's now picked up a new DWI. You want to do now outpatient treatment in the hope she doesn't pick up another DWI?
No, I'm willing to put her in.
Yeah, let's see. Let me talk to them and figure out how we can, what other avenues we can use. And then, yeah, I'll let you know. Okay.
Completed 2A.
That's what it was? Okay. What's easier, HUA or Safe P?
2A, then we will go up to C.
Okay.
There you go. We'll see. Okay, see you Monday. Hi, counsel, come on up. Hi,
Did you want to file?
not yet. Pressa. Oh, oh, Tony, can I borrow you for a second? Come up, Mr. Pressa. Do you have a son?
I'm sorry.
Do you have a son? A son? Alvin? Is it? Alvin's
Oh,
not
yeah,
there.
yeah, he's my nephew.
Okay, all right. I just absolutely love Alvin. He's just so great.
Oh, okay.
Yeah.
I'm glad to hear that.
Mr. Pressa, you're here for yet another bond violation. How many does this make with Mr. Pressa? Victoria, or Veronica, please?
I believe this is his second year.
Yes, it's a second DWI. But while he's on bond for DWI, he picks up a new case And then now he's got more bond violations. Second bond violation? Okay. Anything that you want to add?
Yeah, I wanted to visit with you briefly. If you have one.
You can, but as far as I'm concerned, he just continues to violate conditions. He's just, it's over and it's over and it's over. And you have to understand, Mr. Presa, at some point, we have to hold people accountable. You cannot continue to pick up cases, have bond violations, and expect good results. Do you understand? You will now go to jail. I'm revoking your bond. So I'll put him in back and you can talk to him and we'll go from there. Yeah, but it's just too much. He's picked up a new case while he's on bond. He continues to have bond violations. I can't, just some point, the guy don't be held accountable. Yeah, tell him I absolutely love him. Give him a big hug from me. Take care. So 10,003 on each. Sorry. Skip. Hey, Skip, how are you, man? Yeah, they're supposed to both be on today, but yeah. Sure. Well, yeah, what? Yeah, conditions continue.
Well, and it was for the order, it wasn't even voting on the official. Okay, well, so right now, I think that's until I. I think, yeah.
There's gonna be two fun parties.
But it just needs to rise. For now. It's a lot of time. But yeah.
Bottom of page 1, did she show up?
No, Judge, and I'm emailing Judge now.
Okay,
Because that was one that lived out of town and he
Sure.
said he was probably Friday or Monday.
yeah, I said Friday.
Oh.
She's supposed to be, no, she's supposed to be here today. Yeah. And then there was another lawyer who appeared on Daniel's behalf. I asked the person to sign the motion to sub and they never did. Don't remember.
I don't remember.
It was-
Talk to me, but I don't know.
Karina, on Anderson, there was another lawyer who came and spoke to me and asked me to move it to another day. And I denied it just because of how old it is and how many issues we've had. It wasn't Mr. Daniels, it was someone else. Do you, by chance, did you write it down?
Miss Anderson?
Yeah.
I don't know, I know he works with Cedric Davis, but I don't know who else he works. I've seen.
Was it maybe Flood?
I've seen the one discussions in there, but I was.
Oh, I can't remember. I guess they never filed a motion to sub, so we'll
I know Brian, because he was one of my previous.
yeah, he was a good guy. I like him.
Yeah.
Is 10,000. And how many times has she failed to appear? I know it's a couple.
Today is the second time.
All right, so 10,002. What was the first one?
July 5 of Veronica, do we have the results on the BPR? The A last name?
I don't think he can. Oh, no. This one's little, but
Yes, so I'll just close to Monday. Yeah, I just asked
I mean, I always leave you.
He's a customer, I have to. No, yeah, this is there. Yes.
So you can.
Of course. I'm sorry. That's all I need to hear.
They gotta take, they gotta.
I need to put another BVR on for beginning of next week. What day do you prefer, Monday or Tuesday?
Wednesday.
Wednesday?
Well, just DVRs for Friday, they're totally fine too.
Yeah, but
That's the lightest day. Less action.
thank you.
It's Friday.
I know, right? Hey, I granted.
Okay. You have 3 of them?
So one of them was a business.
Oh, really? On which one? Oh, yeah, but that was because it was a duplicate, that's why. I granted Hawkins and then I granted, I don't know, at least one more.
I'll figure it out.
There's one that's still out on Thompson.
Just one so far.
No, I granted an earlier one too.
Yeah, I know.
You got that one, okay. Yeah.
Because I'm missing 3, so I thought you had 6.
Hey, Skip, you ready? Yeah, come on.
How are you? Happy Friday.
What's up? Happy Friday to you.
Oh, Judge.
You look great, man.
Thank you.
You're looking
You
good.
know the struggle.
Oh, I know it all too well. I love to eat, man.
It really is. So Your Honor, I'm here for 10 gift tacos. It's actually 2 cases where there's a bondsman to turn themselves in and get a bond. Actually, one actually has.
So one's a new case, one's a BVR.
So yes, Judge. So yeah, 2 defendants though, or 2 defendants. One
Different.
is, yeah, 2 different
Okay,
defendants.
what do you want to do first?
I think we should do, please, the one that was already here, the BVR case.
Okay.
Which is, Cookie, Mike Cookie. K-U-Q-I.
Oh, that's right. Where is Mr. Cookie now?
So he is here in the courtroom, Your Honor. See, back.
Come up, sir. Is it with the?
And Judge, those already have 2 $10,000 bonds. One for the $10,002, I think.
Oh, is it warrant?
Right.
Okay, what's the cause number, please?
The cause number.
Either.
For the bond one, Your Honor, is 2514905.
2514906.
Oh, okay, I'm sorry. I see
Right, or-
05 in here, but.
No, okay.
Okay, I'm sorry.
Neither, because I have a Rubio on 2514905.
That's what I think it says here, Judge, but if it's not.
I didn't.
It's 263
Okay, hold on. 263.
425 H.
I think that's the new case, right? That's the interference.
That's the interference, yeah.
About the racing on highway.
Yeah, I'm talking about the racing on the
Okay,
highway.
Judge, that one's 261 490 5.
Yeah. Is that, say that
That's what
there?
I have. You said six.
Huh, that was weird because it didn't come up. Anyways,
So, Your Honor, he was supposed to appear before you on the 19th, but he's got a great excuse for that one because this form, Your Honor, from the bondsman has him appearing on the 24th.
let me see.
So, may I approach?
Yeah.
With permission to publish. So, Your Honor, again, I think that is a reasonable excuse, Your Honor, for him not appearing.
2514905. Yeah, they got it wrong by one digit.
They got that wrong, Judge.
Yeah.
And-
Nevertheless, though, we did send notice for the bond violation hearing to be had on that day on the first case, and he still didn't appear. So I will give you the benefit of the doubt on this one because it's incorrect. But I sent notice to Tim that this defendant was supposed to be here on that one bond violation hearing, and he did
And I
not.
could not deny that, and I can't misrepresent anything to you, but I can't say that I don't know that he got that notice from.
But that's up to them.
I'm not saying he
That's-
didn't, Your Honor, but I'm saying I can't.
Yeah.
You know what I'm saying? I don't know that the court would know that he had actual notice.
Well, that's on Tim and that's on them. I send emails, no.
Can we
He
all take
picked
one?
up a new case while on bond.
I understand. Oh, no, and I'm not quibbling about that one, Your Honor. You have a $10,002 bond on that, and I'm not quibbling. That is what it is. I respect that.
I will reinstate the new one.
That's the one that I'm asking.
Yeah, yeah, of course, because
Okay.
it's obviously
So we're good, Judge.
their fault.
Yeah, we're good on that.
Yeah.
So, okay, well, we have Mr. Christie.
So he's going into custody right now on the
He
racing.
has the bondsman.
I'm not letting him do a walkthrough. No.
Okay.
If
Understood.
you picked up a new case, there are consequences to action, Mr. Kuki. When you continue to pick up new cases, you don't get rewarded. You understand?
Okay, I understand. Again, I don't have to judge your.
So, no, that's not true, but my issue is that when we're too nice to people, certain things continue to happen, and you need to understand that our bond conditions have teeth on them. And when you play, sometimes you make it, you understand, right? So, what was the bond amount on that one?
His arraignment setting was 817. He came in on that day and we took him into custody for the new case.
Okay, so he's,
The issue was that when he went into the holdover and he bonded out and didn't come back to court once he was bonded out because of the date and stuff, his bond was revoked. So we did take him for the new case. It's, the BVR was filed and then.
okay, I mean, I trust you. If that's what you say, that's what you say. The bond on the old case, or I'm sorry, on the new case was 5,001. That's the surety bond that he made.
Yes, Judge.
So can I go ahead and reinstate that to 5,001?
The city.
Yeah.
Judge.
Because it's the bonding company that messed that up
Yes, Judge. And that's what he here tonight.
on the interference. And then,
It was a $25,000. Yeah. Sorry, 2,500.
okay, so I guess I'll reinstate the 10,002 then and leave that as is.
One was 5,001 originally and the other was 2,500.
Okay, then I'll make it at 5,002 on the racing and I'll reinstate it. And then we'll do 5,001 on the interference. And I'll reinstate that one as well. Tell me, what time of day or night are we having here with both of these cases? Are they in the middle of the night? What kind of conditions do we need to place to ensure that Mr. Kuki doesn't pick up yet a third case or have any kind of violations?
That's no problem.
You never know in this
Judge,
life.
I'm asking.
I have people that have 8 cases.
No, I understand. I'm trying to reinforce what you're saying to him.
Judge, on the interference, they don't specify, but the officers arrived to the residence for his brother. It wasn't for him. But he just got in the middle of the detained of his brother.
Okay.
And then on the racing.
And then does he have a license to drive?
Racing.
Or actually, he has a prior reckless driving. I'm ordering him not to drive at all. And I think that I've already made that clear. Let me see on the racing case. I have to imagine that I've probably done that already. Yep. So, Mr. Cookie, the worst possible thing you can do in this life at this point is violate any of these conditions, because I'm telling you now, your bonds are each at 10,002, no fault of your own. On the new case, I will reinstate it, but if you pick up a new case, if you violate these conditions, I will put you over my knee, and like a little child, it might not go well between us. Do you understand me, sir? You were ordered not to consume alcohol or illegal drugs, and I'm going to test you like crazy to make sure that you're not using. You will be tested in a manner of 40 to 50 days. It's not if, it's when. You are not to drive at all. I don't care what you have to do in this life. If you drive, I'm telling you now, oof, you understand. Do you need the cause numbers, Veronica, or do you have it? You got it? Okay. So no weapons as well? No alcohol, drugs, random UA, no driving, bond, reinstated at 5,001, then on. How old are these cases? Do you know? Are they old? Let's see.
Judge,
One is
relatively
around
recent on both.
4.5 months. Okay, so we're going to give you guys a 30 to 40 day setting from today.
Yes, Your Honor.
He must be here at the next setting because he's going to get tested. And then can you put offers on the case now? Because I can't imagine there's much evidence that's just outstanding anyways.
Yes,
Says, okay, all right, Skip.
Thank you, Judge.
Thanks. Once he signs conditions at that point, he's free to go. Thanks, bud.
Oh,
No.
do you want to deal with the other case?
Oh, yeah. I'm sorry, for sure.
The other case, Your Honor, is Motel.
Thank you so much.
I have.
Let me give you ready for the cause number? Bless you.
Your Honor, I'm getting that cause number right now. It is 262-7479, Your Honor. Eric Velasquez Motel.
Do you need a translator?
No,
Do you mind bringing him up?
yes, Your Honor.
479.
And again, with this case, the bondsman is here as well, Judge. That is a criminal mischief. And I don't know obviously the facts, to get into the facts, it was a spat with a tow truck driver.
Let's find out. Mr. Velasquez, you're charged with criminal mischief. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Okay. On June 24th, 2026, a deputy responded to a criminal mischief call at the 2900 block of Berrywood Bend Lane in Harris County, Texas. The complaining witness, who was a private tow truck operator, stated he attempted a private property tow of a white Silverado parked in violation of community rules. As he lifted the vehicle with his tow truck, the defendant arrived, became agitated, climbed inside the Silverado, and attempted or accelerated the rear tires, spinning them with force and pulling the truck off the raised tow forks. The complaining witness confirmed the event and feared the truck or tow rig might flip due to the violent movement. Then they provided video showing the events.
Judge, can I respond to that?
Sure.
I don't think there's probable cause, Your Honor, that a crime was committed because there's no damage to the property of the tow truck driver. There's no evidence of damage to any property, if even to his property, which he's in the right to, damage his own property, Your Honor.
Well, if you are getting towed and you're on the lift and then you try to take off, certainly there can be some. I didn't hear an amount though.
Judge, there is damage. There's $1,200 in damages to the tow truck.
Okay, and they see that it was him that
And
did
there's
it.
photos of the damage to the tow truck as well.
I just didn't hear that, that's probably.
Yeah, that's okay.
It was.
Mr. Velasquez, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to have any contact with the complaining witness in this case. Do you understand? Does Mr. Velasquez have a license to drive, guys? If you do have a valid Texas driver license, one of the other conditions is you are not allowed to drive unless you have valid liability insurance in your name. You must have car insurance. If you don't have it, then you're not allowed to drive, and that is also a condition.
Yes.
No contact with the complaining witness, no weapons. I'll set the bond at or are you guys okay with the PR bond on this, guys? Oh, that's okay.
Driver's license is eligible.
Okay.
I think three judge, it has two DWIs.
But you would be opposed of, for any fair bonds to this criminal history, yes, I would probably be the second.
Okay, how old?
From 2020.
Okay. I'm going to grant you a PR bond. I'll set your bond at $100. I want you to understand something, Velasquez. This is not a revolving door. If you violate these conditions, if you endanger my community, if you pick up a new case, it might not go very well between us. Do you understand? We will have bond conditions created for you to sign. Once you sign them, at that point, you'll be free to go. So PR bond granted, bond set at $100, and go from there. Please, you got it. Thanks. You too, guys. Can you file those conditions, please? Okay, are you ready? Thanks for being patient, guys.
Next cluster.
Welcome back.
Welcome.
Great to see you, Val, like always. Happy Friday.
Good to be seen.
Yeah, yeah.
This is on Miss Jessica Franklin.
She's in custody now.
She's in custody, Your Honor.
Okay.
So there's a interstate compact issue with this one now. So she was on courtesy supervision here for a case out of Los Angeles, California. She was required to complete 120 hours of community service. I've shown Dave the correspondence from her officer here to show that she did 124 hours of community service. That information was sent to the officer's supervisor, who I assume was supposed to have sent it to California. Now, the weird thing here is that the warrant for failure to appear was issued in December of 2025, but they continued to supervise her here, and she continued.
Maybe they just didn't know that the warrant had issued, you know, I mean, that could be here, because from what I've seen, most probation officers aren't gonna every couple months look to see if a warrant has been issued or not. You know, they just get, hey, by the way, warrant's issued. So
So
what would you like?
Correspondence here showing that in July, she was told complete her hours, and then in August 10th of this year.
Val, what do you want?
I don't know what we can do, because I think as soon as the interstate compact issue is put in the system, the fugitive issue has to be dismissed.
So this is where you're kind of in the middle, because the interstate compact holds is in place, but the case file hasn't been created. So I have to wait until that happens. In the interim, while it is still technically and legally a fugitive case, I'm still bound by the rules of the ICA, but in the interim, I think what we're trying to figure out is, because the infraction resulted from a potential miscommunication by the state and not by defense, is that in the interim, Val's gonna reach out to California, because their probation office, so it's ultimately the court, not the DA's office, it's gonna be the court that sees if that email is satisfactory to recall or to satisfy the probation, which they would tell their ICON's office, which would tell Texas ICON's office, which would tell the sheriff's office, which would tell.
If you're gonna try to rely on anyone else, don't hold your breath. It's probably going to have to be you reaching out to the probation officer and just putting pressure on them to look at this, and then get it to the right people so they can either, cure the warrant or what.
I'm sorry.
No, I mean, because right now it's still technically a fugitive case, the kind of middle is to roll it over until Monday, until that hold is actually placed, because it can't, until that's entered as a case, I'm not gonna dismiss my fugitive case, because I have to make sure that hold is placed, otherwise she's gonna get.
So
Or services.
my issue is whether or not this court has any powers to issue any relief to her. She has 5 children, 2 special needs. Obviously an issue with probation because they did not correspond or send the information properly to California to show that she.
Would you be opposed to a
Oh, sorry,
bond?
I didn't realize that's where you're gonna go. No, she can't be released, because even if that's the case, the hold is still placed. My concern wasn't necessarily the other case being out, but the hold is still placed with the sheriff's office. So the ICA is gonna control her release. So even if Judge, you set like a 50-cent bond, the ICA is gonna withhold her from getting out.
Okay.
So today was just in terms of a check-in is part of the talking about bringing her out in motion.
I mean, let's do this. I don't want to just roll it to Monday. We'll roll it to some other day next week, but we've been rolling cases day for day and it's been such a problem that we can't have people coming up because it's just too many. Nothing's going to happen on Monday anyways. It's going to take you some time to even reach out and get a judge to recall it regardless. It'll probably, at a minimum, 2-3 days just to get anything working.
It depends on whether the correction, the mistake really was on the state and whether they choose to correct it. Because if it's that case, they can recall the warrant within hours, assuming that's what it is.
But we don't need her here for that.
Oh, that's right.
You know what I mean?
Also, Judge, if they file appropriately on the interstate compact issues, you're gonna have to dismiss.
Right, if they recall the warrant.
So we don't need her here for regardless. So put her on for Wednesday.
Okay.
It's our lightest day. And then let's see what happens between now and then. If in the interim you want to get a bond or you're eligible to, just come back and we'll talk.
Okay.
I'm not opposed to giving you one of just community service issues. I'm not opposed to
And
it.
to be clear, the warrant isn't for the community service issue. It's because it's an FTA for failure to appear based on the initial.
Sure, of course.
So that's, well, and that's why it's the issue. If it was just a matter of submitting that, we wouldn't even be here, but it's because it's a secondary follow-up that she missed.
Yeah.
It's technically an FTA warrant.
Yeah.
So.
Yeah.
We'll bring it back on Wednesday and I'll start.
Okay, good luck, man. That's why you make the big bucks.
Thank you,
All
Judge.
right, Judge, thank you.
Good to see you, Val. Hi, Marcus, you ready?
Mr. Garcia.
Okay.
Garcia.
Yes.
Do you, Garcia? Oh, thanks. All right, good morning, Mr. Garcia. Sir, you're charged with driving while intoxicated. It is elevated to a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is 3 days in jail with credit for the 5 days that you have done. You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. This will now reflect as a conviction on your record. From now on, if you pick up any further DWIs, you could be facing at least a minimum of 90 days in jail. You understand? Is this what you want to do?
Yes.
How do you plead to the offense of DWI? Guilty or not guilty? Driving while intoxicated. Is it true or untrue that you had a 0.15 or above?
That's true.
All right, I'm going to find it true. I'm going to follow the agreement, send it you to it. I'm going to suspend your driver's license or ability to drive for 180 days. Do not drive until you get a license. CC. And good luck to you. Thanks. Thanks, Marcos. You got it. Joe, what's up, buddy? Happy Friday. What's up?
Your Honor, I'm doing Sosa Rangel.
Sosa. Is this a new case?
Yes, sir.
Awesome. No, actually, it's not an old case. I mean, it is an old case.
We have second, what's been on this, I'm not supporting her side, she wants her for rain, but I thought she's.
The case is 210 days old.
Are waiting today that she told me that she's sending to us the restitution form amount.
Well, so typically what we do, Joe, ma'am, we have a lot of cases on our docket. And at some point, we have to put a cutoff point because otherwise our dockets would be even more out of control than they already are. We set cases for trial at 180 days. Your case is now 210 days old and it's time to put this baby to bed. What we're going to do is I'm going to reset your case for 30 days. At that time, you must come back and you must make a decision on what you want to do. You must either accept the plea bargain agreement and have everything done, or your case will be set for trial. Do you understand? This next reset, you get no more resets after this, other than a trial.
Thank you.
Do you understand? Does she have a license to drive? Sorry, Mr. Garen. On Sosa Rangel, does she have a license to drive, please? If you do have a Texas driver license, you are not allowed to drive unless you also have liability insurance in your name. If I find that you drive without either, then I will revoke your bond. Next time, it's just great. It's just really not going to go well. Do you understand this? Okay. We'll have you sign a reset and then we'll see you in 30 days. Thanks, Joe.
Right this way. Judge, was that free trial on?
No, just send her on her way. Just 30 days, plea or trial.
All right. All right. Council about is. Oh, September 24th.
This is.
Spanish speakers.
See how far through that?
Yes.
Counsel, you're here on.
Juan Rivas, Judge, but we're waiting on an interpreter. I was just got to the state.
Okay. Mr. Garen,
Yes.
good morning.
Good morning, Judge.
Hey, what's up?
Not on the docket today, so this is on
The trial case?
Yes, Judge.
This is Mr. Ortiz. I'm not, excuse me, Mr. Garcia. He has two murder cases pending that are post this charge. We're set for the 20th. I'm asking them to dismiss it now as opposed to waiting until the 25th. They need to talk to the felony and see what felony's direction is. That, what I just handed to you was just put on the 18th, showing that he's having mental health issues. Although I think he may be competent, he's hearing voices. On the 25th, I've had a motion to suppress that in federal court. I was trying to have it resolved before the 25th.
Great.
That we don't.
So can we keep it just in case?
Judge, right now, I got advice counsel, when I get out of here, I'm gonna talk to Ms. Marshall, looks like Michelle did reach out, she might be out of the office. But we want to just confirm or answer any questions you might have before we officially dismiss.
Okay, I won't hold you to it.
Yeah, well,
I was explaining to him that we didn't have that speaking trial warrant right now, so I was like, you're not.
Yeah, you're not up. We won't hold you to it. Don't worry.
it's a kind of it's a double-edged sword again. Not that because it's not double-edged, but I want to keep the pressure because I want to dismiss. But I also don't want it to be moved off to where it follows to the felony.
What would you like?
I would like it dismissed today and with a thank you.
I would like more hair. Is that going to happen?
No.
Well, come on. It's theoretically possible.
You could because the complaining witness understands he's suffering from mental health issues and this is a family assault. It's a slap. It's not a choking or it's just a slap and a breaking of a computer because
I mean, I can't control whether they dismiss it today.
All I'm asking from you is that on the 25th, if I'm not standing here because I'm in a suppression hearing in federal court, if you don't send the bailiffs to come find me,
Denied. I'm kidding, of course. Don't worry about it. Well, and then,
I told him, give him an answer hopefully today.
I mean, this is in the grand scheme of things, right? But I get it. It's up to
There
you.
was, I was also, I emailed the prosecutor and.
Are you representing him upstairs too?
So I represent, so he's got 3 felony, I represent him on the ag assault,
Right.
and then there's 2 murders that Eddie Cortez has him on.
Oh, Ed's got it. Okay.
And he's been no bonded up there, so he's not going anywhere on those. It would also, the logistics of having a double murder suspect here in court without shackles. There's a lot of reasons why that don't show up as law, that's why this case should be dismissed.
I guess, you know what? Why don't we regroup on Monday then? Because if you haven't made a decision by Monday, they're going to bring him on Tuesday.
Oh, that's true.
So you can always zoom in. I have Zoom. You don't need to be here. So it's, as long as you just zoom in from wherever you are, just not in a bathing suit. We're cool.
I can be here on Monday morning.
Okay. I would say come later on around this time because we do a lot of arraignments and stuff. So maybe by 10.
Yeah, I'll come by Monday and check out and then,
I'll be in as well today, but
Yeah.
we are not.
I'm gonna give that back to you.
Yeah, it's interesting that this got filed in your case, but not in the felony. I don't know why maybe because we're set for trial, they were.
Maybe. There's no rhyme or reason sometimes
I
to.
don't know, you know. So we want to go ahead and put it on the docket on Monday, or do you want to just leave it just?
I think just off document, so they don't bring them up.
Okay,
Okay.
I'll come by Monday then.
Okay.
Drop
All right,
it
cool.
in. Garcia. It's for Mr. Garcia.
Garcia's the. He's. that twist.
Tuesday, right?
Yeah, we're not gonna go on.
Okay, I'll see you Monday.
Okay, thank you.
Okay. Hey, Ms. Johnson, coming up.
Judge, he doesn't need to be here,
Who?
depending on Monday.
No. He's set for trial Tuesday, but we're trying to, they're trying to work it so it's done before. Hey. What's up?
Not much, just approaching.
So we can't do the thing where we're rolling people day for day anymore. It's gotten out of control.
There was one specific case that I felt it needed. She was on the ICA. My client's on the ICA. I'm gonna point out for Florida one. She has an ICA out of California, but she's been there since May and has no idea why. So I was asking them, okay, well, what's the reason she's being held? I'm trying to, she has to answer questions that I can't answer. I want to just reset her from a month down the line and I give her answers there. So this is
Sure,
but asking Dave, he had information. He's like, he doesn't have it, but I mean, what do I tell her? I gotta be able to tell her something instead of just, so I asked him, you get the information, find out where exactly it like, so. If you guys send, I got one email saying that California hadn't gotten that report yet. Then I got another one saying that they got it, but they were waiting for Texas to send them the report. And they had time to pick it up. So I'm like, I'm getting conflicting information. So I sent Dave an email saying, give me the real what, when, where, and why was the deadline. So I can get it. So.
Right, but from now on, we can't just roll it day for day because the problem is there's a lot. Number one, the defendants get super frustrated coming back here every day because they get up at 3 a.m. just to get here. They end up taking it on at Echegoin, they take it on at Deputy Williams, they take it out, they beat the hell out of the bars back there. And on top of that, they get commissary 1 time a week. So if they get here on a day that, then they're out commissary for the whole week.
Oh, my client.
So.
She like, we come back tomorrow. I'm like, oh, probably.
Yeah, but we're not gonna do the daily rolling over anymore. I mean, a week, okay, but it's too, 3 days last week, we had
Okay.
so many people here in jail that we couldn't bring everyone up that had to come up for other cases that were on the docket. So then those people got to get rolled and it just becomes a vicious cycle. So.
So don't do more less than a week in between it.
Right.
Okay.
No more rolling day for day because it's just, and it's not just you. There are other lawyers that do it as well. And the problem is when they start compounding it, then we get other defendants who are supposed to be here that can't be here. And so,
Understood.
okay.
All right, thank you.
But have you been able to figure out the issue with?
Over there, Dave?
Are you talking about prepared today?
No, we're talking about ICA.
Yeah.
Yeah. The California stuff.
Okay. So, because that one is a little unusual, because technically, that's not this case. We're just waiting on that case to affect ours. So.
And now like my primary issue, there is California thing, I'm falling forward on a point on our California test.
Not a big deal, but I want to set the expectation going forward so that there's no more issues, especially with defendants who are supposed to be here that can't be here because we just have too many people. We are literally taking space in court 8 because we don't have enough space.
Yeah, this is one where effectively for this fugitive case, it's the same as tracking the local until they process all their ICA matters, which we're not assigned to. That we're just gonna wait until it's finished. As far as we're aware, they haven't finished the post-hearing requirements for notification. Because if they elect to extradite, because a lot of the circumstances are not discretionary for ICA, they have to kind of come up with that's part of the agreement between the states. If they do take Young to California, then obviously the Florida fugitive case will transfer, but we don't have an answer to that yet. You just know.
Let's set it off a week.
It's gonna be longer. I mean, we can set it off, and that's part of the conversation is, I don't know what works for both the court and you. I don't know how far out it needs to be and how far out people want it to be.
No, understood. If I can get the contract, I'll do the legwork. I just don't want to keep telling her, yeah, I don't, you gotta come back in a month and I have to give her a reason why. If I need to reach out to Cali, I don't mind, who I need to talk to, I don't have any information.
Well, and for ICOTS, I don't have any extra information either for California. I would literally Google ICOTS and work from there. I don't have any special information as it pertains to, right, so.
We're currently reset for 9/16 for you.
Yeah, if something changes in the interim, then you can put it on earlier, always. But I don't want to just keep, okay?
All right, thank you.
Okay. Hey,
What are you on?
coming up. Is your client on docket today?
Yes, Your Honor, it's just one, he's a Spanish speaking judge, but we do have a translator here.
Oh, great. I signed your order already, if that's what you're here for. Yeah,
I just have to approach on, your bond.
okay. Yeah, is it for the same one?
It's the same one.
Just let Veronica know. I'm cool. All right, Tony, you ready?
Yes.
No.
Buenos días, señor.
Mr. Rivas, you were charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
Yes, sir. On August 13, 2026, an officer was dispatched at 5900 Old Spanish Trail, which is a public roadway in Harris County, Texas, in reference to a crash major. Upon arrival, the officer observed the defendant standing next to his 2009 Ford pickup truck. The officer then spoke to the wheel witness, who stated she was traveling westbound when she observed the defendant
Hey,
traveling
remember.
eastbound.
She's translating.
I apologize.
So,
The officer then spoke to the wheel witness, who stated she was traveling westbound when she observed the defendant traveling eastbound, and then he entered the opposite lane of traffic. The wheel witness stated she stopped, but the defendant still ran into it. Field sobriety tests were then conducted. With 6 out of 6 clues on the HGN, 8 out of 8 clues on the walk and turn, and 4 out of 4 clues on the one-legged stand. DIC was read, and the defendant consented to breath test, with the results being a 0.134 and a 0.130.
Does he have any priority to BIs?
No, he has no criminal history.
And license?
No, he does not have a license, Judge.
Mr. Rivas, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You didn't say there was alcohol in the car, did you?
No.
If I find that you're consuming alcohol or illegal drugs, your bond can be revoked and you can go into custody. I don't know what your immigration status is, but if you are not in this country with permission, and you go to jail and immigration finds you, it may not go very well for you. You understand? You do not have a Texas driver license. You are not allowed to drive. That is also a condition. I'm going to have you sign with me a promise that you're going to make. This is an affidavit. And I take it extremely serious where you promise us that you're not going to drive. If you do, you can be facing a lot more jail time. You understand? All right, we will have you sign your conditions. After that, you'll be free to go. Thanks. I need to make more copies.
Council for McDowell?
Yes, but the issue was he said no. Turned out he was saying I just thought it would sign it off. Just for that, I agree.
You see how big our numbers are? It's really.
Thank you, man. I'll get that taken care of.
Because of the that have shown. So you could run the reciprocity sheet and have it just launch.
Chumley?
Okay, sounds good. All right, okay.
The lady left the conference. Appreciate
Oh, sorry.
Did you get something like this when you first went out of town? Was it from? We had so many.
Release had signed earlier from McDowell, pre-trial just said that they didn't have the notes of the PR bond, so it's sort of confirmed.
Yeah, yes.
Yeah. In like 2 months. After this wall, because we already assigned who was supposed to be all, so it's like, well, they're trash, yes.
Jen, you have an important call.
Velasquez?
He's right here. He's right here. Ramona.
What's up? What's going on?
They haven't called me because Andy had.
Thank you.
I'm not with a single thing.
Other than they're coming and picking up, but. Well, he made a bond, I don't know if the court accepts the bond.
That's what we're trying to figure out.
So. Okay, so, yeah, I mean, ultimately. Well, you can't get it. No, because that releases the whole hearing. He's the boss. He's gonna get a bond there. Like, theoretically, he could have a dollar bond. He goes to a coach, he can't go to a big company, he like 7 charges.
So the bonds that.
All right, thank you very much.
They pay their 70 back.
That would be called for it, and then I would dismiss my case. Yeah, all the time, Las Vegas, Clark County. What's not?
There's bonding now, there's a bonding company.
Oh, you know, it's very common for other jurisdictions to set a bond number, but that has to be paid in the state.
It's there, that's the joke.
No, I know, but they don't accept it unless their body is in the
Hey.
state. That's what I'm saying.
Hey.
They can put a number.
Hey, did you read it? Did you read it?
To that stage.
All the, what you printed out, some of it.
Did you go all the way down?
No.
You go all the way down.
Because sometimes they don't.
Take a look.
To me, because the security is. They
They
can always
haven't
say,
given us,
it's very rare that they tell us, you have to tell the sheriff's office, they give direction.
Yeah.
I just mean like, we have a date.
Oh, you're talking about the phone.
But that 15 days, so it's. It's
gonna be the second.
September 2nd.
Here, then.
Not all of them, not all, some of them. The statute gives me 30 days, Ms. Fleischer and doesn't follow. But that's not code, that's just.
So he does, he goes after this issue.
Sure.
He does interview this, if it goes with it, we'll still have to warn. It's only.
What happens is, it's not that they dismiss it, it's that it allows them to withdraw the waiver, so they can bond, there's a death penalty for that person.
Yeah.
So they can withdraw, it allows you to withdraw the waiver.
All that happens. The police will come down playing.
Yes, they drive back on fire.
I bet she got one too.
Let me go.
I bet she got one too.
I bet so, yes.
All right.
Okay. I need that, we need that in confirmation, that's actually what, that's actually what your flight was, and you want for the date, you can send us an email.
Yeah, that's what I'm doing, yeah. Let's see what the police want.
It's just a matter of.
Ramona. Ramona.
Yes, Judge.
Can you be ready to go on the record, please?
Sure. I'll come out there.
Thanks. Hey.
Why don't you ask that? Okay, court 10.
Thank you very much.
Yeah, you're welcome.
Hey, did Justin roll someone 3 days in a row too?
This one, he got it on Wednesday, the 19th.
Mm-hmm.
It's yesterday.
So, hey, what I'm gonna say is no more unless there's an extenuating circumstance, and you just gotta always approach if something's gonna get rolled, but that's fine. So we gotta confirm with,
Okay.
Yeah.
I hope it's gonna start motion for everybody. Didn't see what it was.
I would, if it's too old, I guess, yeah.
Oh, maybe I'm misunderstanding.
Oh, yeah, yes, no, yes, yeah, no. So if they're doing a waiver, the state gets them brought out, so they can be admonished, and we can hear it in open court that they're waiving.
Okay.
That's fine. So yes, every time there's a waiver, then,
Well, what if they want to just keep them?
no, because they've already waived and they already did it in PC court.
Okay.
There's no need for us to,
Okay.
they've already done it.
All right. I think, the two that were the one said they were keeping. So they.
He said April.
So then in that respect, there's no need to roll. Yeah, so, right, so we'll just say.
You just, is it back?
Who is that? Who is one?
25.
Do you want to go through the list? Hi, good morning.
There should be a motion in your queue on a.
Discovery, I see it.
Yeah.
Hub?
Yep,
Okay, I'm signing it. It's standard. You didn't change anything?
I did not.
Okay, yeah, I'll sign it for you.
Thank you, Judge.
You got it.
Judge, you ready to go down this?
Yes,
Okay.
Oh.
So page one, the top of one.
2501.
Bottom of two, we sent for a drug test. We'll certify.
Oh.
Bottom of seven, top of eight, two more we posted.
5002. And I got to do a bail order.
Okay.
You said yes, one or two?
Two bonds posted on both cases.
On both. Okay, there's two. Got it. Ramona, are you ready?
Yeah.
Yeah, okay. As soon as he comes back up. Justin? Mhm.
I know. No, I know.
Well, if you can say this person is supposed to sign a contract. I told him to tell us. If you're simply yet, we'll give us a session. It's about.
First, yeah, clear. Oh, already? Yeah, okay. I'm turned off into it. He did? It was in custody. It was on, he ended up getting to the other part of the.
Something happened? Do we mess up?
No, I just know that when during the day, I always put it out, but it's fine, because all the paperwork gets done on the Friday. That's fine, there's paper. It makes no difference to me.
Okay, Victoria, you ready?
Yes, sir.
Who's next?
Page 10, one defendant, one case has 2 counts and one is in the. Page 10,
McNeely.
yes.
So 5002 on both.
Theo,
Yep. Ah,
what's up with the maps and you?
They're going to be. Yes, sir.
Some kind of one with the dismissal.
No. Oh, no, he was Stephen. He was with us.
And Chloe as well.
Chloe goes with you as well. Yes.
Why don't I?
That's a great idea.
Hey, come back.
We're picking up what I'm reading. So they were from Monday. Yes, great. Thank you so much.
Okay,
Judge. Problem 12. Did council say anything about a plea? I didn't hear it was up there.
on bottom of 12, no, I'm not taking, no.
Okay.
I put them in custody,
For how
Or no-
much, Judge?
10,003 on both.
Bottom of 13,
2501,
top of 14,
2501,
bottom of 15,
5002,
Leo,
yep.
It's my laptop would be hard to watch, so. when I thought it-
I know, that's what I was doing the other day. Last week.
I'll think.
Okay, who's next?
Witness meeting in the back of the hospital.
bottom of 16, bonds posted.
I got shit. People on the loan and.
Same thing, 5002.
Yeah.
I don't know. I didn't have it. So she, when she was gonna eat her phone, she had a clean. But she, when I was supposed to be able to release that same. Because she didn't. She's more than that, she.
Okay,
The last one, bottom of 17,
I don't know.
I don't know what he's talking about.
5001.
Oh.
so the two open are the tester and the Thompson. I think he's talking to her, attorney.
In the tester, I just that, he was able to provide a sample, again, so they're gonna try to retest him and blessing.
Okay, if he doesn't test today,
I don't think it's Is it not mapping?
Oh, no, I don't know. If it was in the-
No, maps, just a figure of key phones.
Without any sort of responding.
No, we're just going to play it, is that not going to be the jurisdiction of this?
Oh, then no, that's fine. Okay, all in our file, my bad.
Your file? Oh,
All
thank
good.
you.
Nonsense. Please tell me.
Oh, we do.
You're not a problem.
I'm just gonna do this like, please, let jump in. No, every time we see it on the cheap top,
I just,
we got some peanuts and maintenance.
well, no, even if it says that, because you don't have this,
Oh, yeah.
but it's good to know.
Oh, yeah.
Just-
Sometimes, oh, remember when I used to be out, sure. Just aware, if it has a summons status, so we'll have to make sure that these papers are that's.
Okay,
Is that okay?
yeah, yeah.
Because things like work product, you can't even allow, what do you think, privilege in office, what do you think? So you want it.
Oh, yeah. Sounds like-
You don't have to like. show the office. Yeah. You do have to manage the clock, I think it's actually done. I don't know, just like, I felt like it's something else, I do, appreciate you checking. Okay. Yes, but also, you want to be.
About everything. You said that this is something else. You get on.
What's the change? Go back and forth.
Yes. This is one, just so we don't need to do it.
Where's your second?
He's still hoping that.
He's over, he does.
Okay.
Well, he can get back there as quick as possible, but now he can get himself back there faster. They also told me that they did hire a turn to let's talk to that person and see what's going on. He wants to just stick his move.
What's that? Sorry.
Is your person?
Jermaine.
Because if it's 4 days after, if he's gonna want to withdraw it after the morning, then I'm gonna be opposed to withdrawing because the court has to approve it. So. Hold on. Oh, yeah, it's in the.
I don't.
Yeah, it's a felony. Right?
Yes.
Yeah.
It's a fun way to say it.
Right, you're both looking at it.
Yes, so, I mean, if he wants to be eligible for one, because it doesn't have a death penalty or life in prison, he is eligible, but he has to withdraw his waiver if he's eligible, so if he doesn't, it's his whole time. Yeah, that's up to 90 days. He's eligible.
He's told me that's what he wants to do.
Okay.
Oh, much for you.
Hey, can I talk to both of you guys
Yeah.
real quick? Yeah. Guys, we're going on the record. Please keep it down first, just for a moment.
Good morning.
Hi, good morning. We're on the record in cause number 263-5398, the state of Texas versus Germani Levy. The only thing that I wanted to bring you guys attention is that this case was on the docket first Wednesday, was rolled to Thursday, then when it was rolled to today. The problem is that we can't continue to roll cases. We have so many people that are in custody now that we've, at least a couple days this week, we couldn't bring others up because we had others here that were in their stead. It really makes all the defendants back there upset when they get rolled day for day. They get aggressive. it becomes a security risk for Etchegoin. They take it out on Etchegoin, they take it on Deputy Williams, and they start banging in the holdover. They might miss commissary, which is only once a week. So, you know, unless there's a really extenuating circumstance, I don't want to just continue to roll day for day because everybody else suffers. Not only do they don't get to come up, we have other lawyers that come into court, their client's not here because they've not been made up, because others have been rolled. So I don't want to continue the practice of just rolling it day for day. If there's some really, really good reason, then approach and we can talk. But other than that, I don't want to just continue to do it, please.
Yes.
Because it's at the risk of everybody else, and it's just
Yes,
not
and
cool.
I don't think, totally understand all those concerns. I don't think that anybody is asking for this case to be rolled anymore. And we do go on the record on this case each time. I think it should show that last time we talked about this, when I asked if we could just carry him to the roll that day, because there is something kind of going on in extenuating circumstances. It's kind of an interesting situation. I think the state might agree with me on this, with Nevada. And so, but we've run out of those extenuating circumstances. He has counsel now that they've retained, the family's retained in Nevada, so hopefully they can kind of move some things along. And I think the state's gonna ask the court, because that's my understanding is how these fugitive cases work, the resets come from the state. So that's gonna be, we're gonna reset it out.
This isn't
A request for September 2nd. And then if I get any word from Nevada that something's changed and like a warrant has been cleared because he's posted up, they've accepted the bond, he's paid the bond there. I talked to the bonding company, they've gotten the money. I'll just find out why the court's not accepting it. If they do accept it before then, I'll just come let the state know, and then if they can talk to the court, if they need to change.
Was this an ICA case?
No, Judge. It's just a matter of,
Had he already waived?
yes.
There's really, if they've already waived, unless on the day that we have them first, unless they want to pull that waiver, there's just no reason to roll it day for day. Because there's really, you know,
Oh, sure, I get that, but what we're
Right.
thinking is that since the family's paid the bond in Nevada to a bonding company in Clark County, and that bonding agent, like, talked to me, that we were thinking it might clear up.
great, but we still don't need them even in that respect.
Okay.
So I'm just trying to give you guys the expectation of going forward. We're just not going to roll day for day for day for day
Sure.
because everybody else suffers because of one person,
Sure.
when there's really just no need.
Yeah, and I get that completely. And I did I was scheduled for an intake term in here today with the MAC, and I let your coordinator know yesterday I got pulled to Galveston, so I canceled that term. So I let the coordinator
Great.
be here first.
Good. You know, we have other lawyers here that have rolled cases for 3 days and don't even show up. So that from now on, if you get appointed a case and you can be here that day, fantastic. Otherwise, if you can't, and I get it because you're too busy here or there, we're going to appoint someone else just
Yeah.
because I'm not going to roll it for another day just because a lawyer can't make it, you know?
I've never asked for that. Yeah.
So, and I'm not saying that you have, but we have other people and I would just want to set the expectation for everything going forward. Okay, you
Yes.
good?
Thank
All
you.
right, we're off the record.
Y'all want September 2nd?
September 2nd, yeah, and we weren't on the record. We weren't on the record. We were in trial. I was in trial. This is the first one.
Oh, on this case? Okay, okay.
Yeah.
Yeah.
I'll get it from them.
Okay,
Thank you.
thank y'all.
That leaves the last person.
Thank you, Ramona.
And he does, he wants to wait.
Safe.
Oh.
What's up, man? Good to see you. It's been a long time. How are things? Good? Great. Great. It's Friday. Finally.
Judge Abel's on his way, just a heads up.
Okay.
You got put in late, so it's just.
I understand. And sometimes we get people late, which is understandable, but that's why we have Zoom, so they don't even have to,
Well,
you know?
because Abel was here and he didn't realize until after he left it up.
Yep, I get it.
And then that's our last one.
Okay, and you guys wait for ready? Let me know if it's. Thank you, Judge.
All right, see you. Have a great weekend.
out there.
But actually, I consider the whole, the research and study box.
I know it's just, to do.
Okay, I talked to Gerald about the bond conditions and I emailed him a copy. I told him if it's not submitted by next week.
But put a day, like a specific day, because if you just say any day next week, then
I can tell him, SFBF on Friday if it's not done. We put the BBRs on Friday.
Okay.
I have no
All right.
issues with that.
Okay. Are we done?
Abel got the fugitive in the back. For him, it was a late one. Because the BBRs on-
Right, but what's the name? No, defendant.
Oh, the defendant Perez, he's a Spanish speaker. Yeah, the issue just with that one was the PDO's office rejected it because they didn't have Spanish speakers, so Abel got it late.
Do we have a waiver on file? Do you think?
Hey, Anna?
Did Perez waive already?
No, he's currently refused. He will most likely probably waive soon.
Okay.
And Abel said he's on his way.
Wonderful. So if you have, say you have your separate trial one next week, does that make precedent to everything else that you're doing? Yeah.
I'm trying to set up these two to all speed. Hopefully, when we have a special time for but I thought there was a most important thing is to see this at the opportunity, because you never know if you have to tell us they have a certain question of the future. But I always think the opposite of the more about it. There wasn't for that is. And then more about everybody else went for CC, the biggest thing was meeting with the kids, and it really with the kids. And that's like their longest meeting before anything else is condition.
And so obviously, for how long is like trial for like in the same case versus like a file?
Yeah. There's a case, if you know a little bit, you were evidence, you know, that you must be doing all that for you, but you have a native officer. And then the bottom of the person, you know, sit where they must watch about my body. Before I mean, make sure you got your body, you must make sure that you go to line on and then you have show the person I want to get in, right? This is a traffic stop, this is really supposed to be, this is like all these things and all these things like an hour, right? I don't go through my questions with them, I'm doing it with questions flow. Because I don't like the question. Okay, I'm more like
You're not the static person.
I was like, I asked about the like, how long have you been with it? You can see, we have a lot of questions for us to know that I should ask this question. And then people are like, then I'll go into like shop of stuff and I'll go into, let's see if you have the topic that I can pick. Make sure to look at this and make sure to look at that. Kind of situation.
Do you have the conversation with them, like, depends if we're gonna talk about it, that's what, and I don't know if you do this, like,
I don't know what potential is.
can you help, like, obviously not positive, what to say, but you can help like frame, how to find that innovation.
This is the potential issue. This is an example last time about like, you know, their some observation and like think about seeing like why you know why was that you got why was that you know like really But I never saw him say this about obviously. And you told me, but I think there's other some issues and try to understand why they did. Yeah. This is, they're not spending so much, it's going to be why this got. It's not like it's. Oh, okay. So, well, I don't know. We don't want to do it, so all this is in it. And then, do you want to help me understand what you take out of the documents, so that you- And then because, like, so these certain laws are not showing, actually, not bloody, you know, so it's just like, I just watch all of the final states.
No, we need the rest of it stays, but let me. Thank you. So they call me?
Thank you so much.
Yeah, sure.
That just comes to almost like control. So that explains that I'm just gonna try and if it's very question, answer the question, answer the question. But. Tell me what happened this week, where you might try to get some details for kids, right? If they have answers, we do things. How do you know what they're gonna say, how do you know what people are like? Those things you try to get with them, so we can phrase your questions based on. So we project to, you know, you have.
Hey, Alyssa?
Yes.
Do y'all have bond conditions on Thompson?
In the room,
Yes, Amy Thompson.
We do, but I don't have the.
Oh, I'm just making sure because I don't see them in there. So I'm gonna check out to resend you to you. I just said, oh, you might have to be a little. Yeah. Okay.
Yeah, Stacy.
Wait on.
No, not yours.
Not myself, you said.
Wonderful.
Yes.
Sorry. Sometimes we get them late.
Yeah, that's what I thought.
That's okay.
We're not trying to make you come back.
I know, I'm sorry. Yes, yes, I know, I try to like send it out so I know y'all can start doing.
Gotcha. Okay, just making sure, thank you. There's some time to. And what like. It's just something that's not really contested, right? That's not really doable to an interest rate based on. It's like something.
But you made it to the.
Yeah, I made it to the. You're supposed to just go on the front. Go to normally, it's are you allowed to do that? And
Oh, don't help us.
He's using the facilities.
well, technically this is what's because they.
Yeah, so.
You can't hold things out, I can't talk to you.
What's up? What's his name?
That is, he's a repeat from Maryland.
He's got an immigration, hey, he's got an immigration detainer, so you know. Anna, did you know that? Perez has an immigration detainer.
Yes.
Okay. I didn't know if you were gonna approach for a bond.
I don't know yet, he's.
Hey, he's wanted for armed robbery, assault, 1 and 2, firearm use in the commission of a violent offense.
Open for the month.
Yeah, it's gonna be. I know, is it carry life?
Yeah. That's great.
I don't believe it's.
What's wrong with you, man?
Yeah. You have time. I would go good. I'm gonna say how far, right? Because sometimes like permission to just pass it. Yeah. It's like.
Are we waiting on more conditions or not?
Just that's the top. That's not, I think top is fine. Amy Thompson. I think she does that. Yeah. And then she'll say. They're gonna go get it for. Awesome, cool.
Points. And if I was going to, we do have your statement.
Just bring them frame this.
But it's like, it's still really valuable because. And what this is going to start. It's just. It's so informal. I was taught to always like stand and all that. And I like.
That's a nice thing.
But we sit. And I just feel like I'm not. Community really. I don't
Jurors don't know that either, most of the time, they see on TV, and then I have actually a juror kind of like. Why would you guys say that you should guys? They didn't look at it. I'm sorry, there's a Texas nation, in Florida, we do.
You can feel like, I feel like it goes, the school is not like. Yeah, you don't have to.
It's the same with Bobby, though, you don't.
Because I had a bigger. So like, I would like to not be able to sit and have like somebody. And I couldn't know. I would have
He needs to be brought out, and he has to sign for a judge now.
Okay. Is that anything? Interesting.
Do you mind bringing him out?
He's back here.
I'll let you translate.
Mine's not right.
I got one.
Okay. Do you wanna look at this? Make sure it's.
It's Maryland. It's Maryland. Why the new change?
Why, what?
Why does the here?
The DA's office is asking that they be brought out so that they can waive an open court, as opposed to just signing it and just putting them.
Do something for the.
Pick and choose your battles, my friend.
Yeah.
It's
I did not ask, I promise.
No.
it's not a big deal.
Do you see if you could unsign the PR bond?
Yeah. Isn't it ready for activities?
I think it's ready.
McDowell?
Yes.
No, I don't see it in activities.
No, and she's ready to publish.
Let's look in there.
Oh, we're doing it out to be, it's almost changed.
He's a voluntary.
No, it's not in there either. Do you see where it is?
It might have moved. It's a I'll look at everything.
Thanks. All right. Good morning, Mr. Perez Herrera.
Buenos días, señor Pérez.
You are wanted out of the
Aquí te buscan del estado de
state
Maryland.
of Maryland for armed robbery ×2, in addition to using a firearm in the commission of an offense. Are you waiving formal extradition?
Y está renunciando a tu extradición, correcto. Sí, tienes que decir en voz alta. Sí, yes.
Okay. All right. Good luck to you, sir.
Buena suerte. Buena suerte.
I think we're done.